The Deception of Nicolini Law Firm continued in 2019, Part 13. Please feel free to pause and read. Statements of claim, wrongful dismissal, and long-term disability created by Adrian Nicolini and Ashlyn Steele's Nicolini Law Firm without my knowledge or involvement. Docket sheet dated August 16, 2018. Review statement of defense for Industrial Alliance Insurance and Financial Services Inc. I'm addressing that, right? This was for long-term disability, right? 2. Why would Nicolini Law drafted statement of claim for the Manufacturers Life Insurance Company and Industrial Alliance Insurance and Financial Service Inc. and did not provide a statement of defense also for the Manufacturers Life Insurance short-term disability and if damages and for damages. 3. Why would Nicolini Law issue a statement of claim without both companies and only drafted statement of defense for only one company? Okay. As you can see, it says here Manufacturers Insurance Company and Industrial Alliance Insurance and Financial Services, right, Inc. This is statement of claim. So here, why would he, Adrian Nicolini, that is, okay, only draft a statement of defense for Industrial Alliance and Financial Services? That's what my question is. Can you see that? August 16, it only have here one statement of defense for Industrial Alliance Insurance and Financial Services, while a statement of claim is saying the Manufacturers Life Insurance, two companies, but only one listed here. Please feel free to review. Okay, anyone can answer that. If this docket sheet was legit, why didn't the responses to the following two letters, September 18, 2018 and December 17, 2018 for MANULIFE Insurance appeared in the list of activities which Nicolini Law Firm stated was for long-term disability claim between July and December 2018? I had retrieved the following two letters from the motion that was filed against me in 2021. Okay, so as you can see here, there's no September, there's no December 17. Okay, please feel free to pause and read. I'll go on the next slides. Okay, so these two I received from the motion, and here they're communicating. Adrian Nicolini was communicating with MANULIFE Insurance, and then you can see MANULIFE Insurance responding on September 18, 2018, right, regarding, say, please find the notice of intent to defend the Manufacturers Life Insurance Company, which is served on you pursuant of the rules of civil procedure. Okay, and then on December 17, 2018, still to Adrian Nicolini, right, from MANULIFE Insurance, it says, further to my letter of July 17, 2018, I confirm that MANULIFE's involvement, right, in relation to disability claims brought by Bell Canada employees relates solely to administering short-term disability claims on behalf of Bell Canada. So you see what's going on here. Okay, they in December 17, they're still confirming that we cannot sue them for long-term disability because they only deal with Bell Mobility and with short-term disability. As I said, I already knew that. Feel free to pause and read. I did some doodles here. You understand? Like 1, whose signature is on the statement of claim? Whose signature? 2, I was unaware that Nicolini Law proceeded to solicit on my behalf without a contract. Okay. 3, shouldn't I receive a copy of this letter or statement of defense? 4, deception. Okay. On the December letter, I doodled. 1, Nicolini Law was intentional to have opened a claim on MANULIFE for long-term disability. 2, deception. 3, my claim on MANULIFE is not for long-term disability, right? But 1 month short-term disability and for damages, all right? I had provided proofs to Nicolini Law, but the firm did otherwise. 4. Now I know why I was not included, okay? Appointment from the Nicolini Law Firm for October 31st, 2018. Reason for the appointment was WSIB, okay? Rose, an injured worker at mobility from my department, had requested to see my lawyer, re-advise on her injury, right? An appointment was made prior to my knowledge that my claim was suspended, okay? As you can see here, you see October 31st, 2018, this lawyer wasn't Benjamin Law should not have been charged because this meeting did not belong to me. The October 31st meeting belonged to my co-worker, and I have proof to show you, okay? My co-worker Rose. It says here, meeting with client to discuss the status of her claim and next steps, corresponding with both defense counsel requesting direction of action and consent to amend the statement of claim. And I have proof to show you that October 31st was not about me, okay? Plans were made prior to October 31st, 2018 to accompany my co-worker Rose to see ADRIAN-Nicolini, WSIB. I became aware that my WSIB claim was suspended in the month of October 2018 after the appointment was with Nicolini Law Firm was already made. The appointment was not for me, but for my co-worker Rose. I took the opportunity after to ask ADRIAN-Nicolini about my suspended WSIB claim, but was told they would take care of it. No explanation on why my medical reports from the doctors were not provided. Okay, Nicolini Law Firm at no time advised that they had begun work on my wrongful dismissal or long-term disability claims, especially without a signed contract. So this here falls, okay? And I have proof. My co-worker Rose, who was also injured at Bell, had asked me to reach out to my lawyer on her behalf. Conversation between ADRIAN-Nicolini, WSIB, right, lawyer, and I regarding consultation for Rose, my co-worker. The appointment was made for October 31st, 2018 for Rose, my co-worker at Mobility. Rose had asked that I accompanied her to the lawyer, therefore I informed the office that I would also attend the meeting. Okay, so you can see here I sent this text message to ADRIAN-Nicolini, WSIB lawyer, on the 27th of September 2018, and it says here, "Good morning, Adrian. I hope that all is well. I have a co-worker who was also denied by WSIB with both hands injured at Bell and is seeking a lawyer. Can you see her for a free consultation and advise her accordingly? Please advise. Thank you and have a great day." And I was telling him that she was also denied by WSIB. Please feel free to read. Okay. Then he said, "Hi, Delane. Sure, I'll be happy to speak with her. Have her call the office to book an appointment, please. Okay, please feel free to review. Thank you." I included this text message conversation between Rose and myself, okay, because of the date, okay, leading up to the appointment. Okay, so from the 6th of September 2018, you notice the 11th of September 2018, she was denied by WSIB and we're talking, she was going to see a lawyer and all that. Pay attention to this section. I have a medical appointment with an ortho surgeon regarding her hands, okay, and it's also on the other slides. Here I did state conversation between Rose and I began in September 2018, continuing on the other slides to make arrangement for an appointment with ADRIAN-Nicolini, which was eventually scheduled for October 31st, 2018. The meeting was only for WSIB. No other cases were mentioned. Please feel free to review. Thank you. The conversation via text was flowing, as you can see from the previous slide, okay, that this information was there. We're still in September when she said I have a medical appointment and all that, okay? All right, so plans were being made to see my lawyer, ADRIAN-Nicolini. See conversation below. Rose, my coworker, requested to see my lawyer for legal advice. Rose had asked that I accompanied her to see my lawyer. Appointment date was confirmed. This appointment was prior to my knowledge that my WSIB claim was suspended. Okay, as you can see here, Rose stated, "Can you arrange for your lawyer to see me?" All right, same thing here. Then I said, "Should I give them the name, Rose?" Okay, please feel free to read. Okay, plans were made. We're still in the month of September, as you can recall, 2 slides over. I reached out to ADRIAN on September 27, 2018 on behalf of Rose. Okay, he said sure. So I provided his number. When I gave Rose his number, she said, "Can you book the appointment for me?" And I did. Okay, so I provided her the information October 31st at 3:30. Then they changed it and I provided an update. So final, it said appointment would be on October 31st, 2018 at 1:30 p.m. And I will send the address. Please feel free to review. Thank you. Send the address, as you can see, that's where the law firm was. Okay, please feel free to pause and read. Thank you. Rose did not want to attend the appointment alone, so she asked if I could accompany her. Okay, and I said yes. We can meet at a point and be there at the same time. We will plan it closer to the time. Okay, and we were conversing after. Please feel free to review. Thank you. I've moved on to the next false information on the docket sheet, January 8, 2019. Their information telephone conference call with client to provide a status update. You know, this is false. I was the one who called on January 8, 2019, right? And I called to inquire about statements of claim as requested by Kevin Marshall Law, which were received on January 10, 2019. January 10, 2019, Ashton provided two statements of claim. First time hearing or seeing statement of claim, okay? This is proof from that I contacted. Here's the voice recorder from Crystal. All right, please give a listen on the next slide. Thank you.
Crystal? Yes. I'm sorry, agent leaving the office right now, and his appointments are concluded for today, so you will be unable to come in. In the future, we do prefer booking appointments rather than having walk-ins. Also, in regards to your claim, it has been issued, but defense counsel they'd like to add someone to the claim, which is why we're waiting for consent from the other party to do so.
So this was done on December 20th.
It was done around then. We added someone to the claim.
Well, because the thing is, okay. So since May, you're saying that there was a claim open, and then because of some changes. What was it that made the change for?
So defense counsel, the other party, they want to add a party to the claim. So we just added the party recently, in December. So now we have to wait for their consent, but the claim has already been issued.
Okay, so I'm gonna get a new number then.
No, it's going to be the same claim number.
Oh.
So Ashlyn said that she can email you a copy of the statement of claim if you'd like.
Okay, that would be great then. Yes.
Okay.
Yes, that would be great.
I will let her know.
Okay then. All right. Thank you so much, Crystal.
You're welcome.
All right.
Bye.
Okay then. All right. Later. Okay. Bye-bye.
Bye.
Bye-bye.
February 13, 2019 also appeared on the docket sheet. Okay, how was that possible? I retained Benjamin Law Firm on February 13, 2019 for long-term disability. HOSSEIN and HOSSEIN MOGHTERDARI sent a letter to Benjamin Law on May 14, 2019, 3 months later, to inform that they were in the process of amending the statement of claim to include Bell Canada. This was actually a criminal act since I never retained Nicolini Law. All this was done without my knowledge or involvement. I was never informed of any amendment. As you can see, Nicolini Law, an intent to deceive. 8 months later, I retained Benjamin Law on February 13, 2019. Okay? When Benjamin Law reached out to Nicolini Law Firm on May 14, 2019, Nicolini Law is going to state that our office is in the process of amending statement of claim. Please feel free to review. I've already been through this, but this is all false information I've just brought forward again for your review. Was this a start to stop the examination for discovery? What happened next? The examination for discovery was scheduled for August 16, 2019. These two lawyers, ADRIAN and HOSSEIN MOGHTERDARI, intentions were to silence me by any means necessary. They succeeded by allowing the system to gang upon me systemic racism.